席嘅選舉嘅嚇，咁咧。
So we need to elect a chairman. Any nominations, please? Mr. Christopher Chong. I nominate Ms. Anne Chang. Any seconders? Mr. Leung Chi Cheung and Ms. Alice Mack. Any other nominations? Mr. Kenneth Chan. I nominate Ms. Helena Wong. Any seconders? Mr. Chen Chi Chun. All right. Any other nominations, please?
好，如果冇嘅話咧
No. As we have more than one nomination, members will now need to cast their votes by secret ballot. So the clerk will distribute the ballot papers and the chops to members. So please please apply the chop against the name that or the number that you prefer. Number 1, Miss Anne Chang. Number 2, Miss Helena Wong.
咁啊，亦都係要提醒大家啦，因為
And may I remind members that you're voting by secret ballot. So please do not let others see your ballot papers, and please do not fold the ballot papers.
係。俾個張左邊，呢張擺呢度先。好，唔該。好，請問有冇委員係未有
Right. Have members finished casting their votes? All right. So, if you have already cast your votes, then voting is closed. Ms. Sit Ho, I've just declared that voting has been closed. So can I please ask our staff to collect the ballot papers from members, and please insert the ballot papers into the box. And please do not leave your seats.
我請。好啊。好，跟住落嚟咧，我想請有份提名。
And now may I invite Mr. Christopher Chong and Mr. Kenneth Chan to come forward to observe the counting of votes. The ballot papers will be destroyed after counting has been completed.
搶唔搶？係。
2號。Number 2. 2號。Number 2. 2號。Number 2. 2號。Number 2. 1號。Number 1. 1號。Number 1. 1號。Number 1. 1號。Number 1. 1號。 Number 1.
1號
Number 1.
好，咁我而家
So I will now declare the results. Ms. Anne Chang, 6 votes. Ms. Helena Wong, 4 votes. So I declare that Ms. Anne Chang has been elected chairman of the Bills Committee. Now I'll hand over the chair to Ms. Anne Chang.
好，咁就多謝各位嘅支持啊！
Thank you for your support. So this is the first meeting of the Bills Committee on Sex Discrimination Amendment Bill 2014. And we can elect a deputy chairman. Do you think we need to elect a deputy chairman? All right. And let's invite the administration in.
Hello. 我記得，好啊，嚇。好，咁我哋歡迎呢就係政制及內地。
So we'd like to welcome the Undersecretary, Mr. Lau Kong Wah, and we also have the PAS, Mr. Zhang, and also the AS, Mr. Yao, and we also have Mr. Ng from the DFJ. So we're going to have a discussion on the bill. Members can refer to our Legal Services Report, LS 69. And the Secretariat has also prepared a marked up copy for us, and also a background brief. And I will now invite the administration to take us through the bill. Undersecretary. Yes, Chairman, thank you. Under Section 40(1) of the Sex Discrimination Ordinance, it's unlawful for a person to sexually it's unlawful for a service provider to sexually harass a customer, but then the ordinance does not render unlawful any sexual harassment of a service provider by a customer. And then I want to say that in the retail industry we have over 260,000 employees, and in the catering industry over 230,000 employees, and we have over 45,000 nurses and over 12,000 airline hostesses. And it is understood that employees in these sectors are more vulnerable to sexual harassment. In order that these employees can be free from sexual harassment by a customer, the SDO renders unlawful any sexual harassment against providers or prospective providers of goods, facilities, or services. And we understand that concerning the work environment on aeroplanes and on ships, we propose to expand the territorial scope of the proposal to cover sexual harassment of service providers by customers and of customers by service providers that takes place on board a Hong Kong registered ship or aircraft while such a ship or aircraft is outside Hong Kong. So the amendment will provide the same protection to service providers and customers. Chairman, the CA panel has been consulted, and at the meeting, some members urged the administration to table the bill in the Legislative Council as soon as possible. And we promised that we would do that as soon as possible. And I understand that members, in fact, all support the amendments. We've consulted the EOC and also trade unions, and we've got their support. We hope to get the Bills Committee's support on the bill. And now we will answer questions from members. Thank you. In fact, the amendments are very simple. First of all, service providers should also be given protection. So it will be unlawful for customers to sexually harass service providers. And then second, such acts on registered ships or aircrafts will also be covered, irrespective of whether the ship or aircraft is outside Hong Kong or not. So now we can have a discussion on the bill. All right. So I understand that 4 or 5 members have raised their hands. Sid Ho, Helena Wong, Kwok Wai Keung, Pun Siu Ping, and Chen Chi-Chin. Did you raise your hand? All right. As we have ample time today, let's give each member 5 minutes, and then we can have a second round of discussion. Ms. Sid Ho. Thank you, Chairman. Thank you. Now, concerning sexual harassment, I understand that although usually we refer to the victims as females, but in fact males are also given the same protection. But we understand that in countries like Australia, there is the so-called the third sex. And so I really hope that we can also progress with the times. This is especially the case because we the bill seeks to cover also aircraft, and so international flights are also involved. And so you're talking about service providers, customers, but then I think we should also cover the third sex. And in fact, I asked the Undersecretary whether the wording should be anyone providing service to anyone, and so on and so forth.
Another question is, since you're going to apply that to registered ships and aircraft and even cruise vessels, well, we have many cruises visiting Hong Kong now. Now, if on that registered vessel, only one party is a Hong Kong resident, or if neither of them are, what is our jurisdiction? All right. The first question, or the first point is just a comment, and second, a question. Mr. Lau. Ms. Ho personally gave me her views before this meeting. I think Ms. Ho's proposal is with reference to other countries. But let me elaborate on my policy intent. While the term used is woman in the bill, but according to the interpretation section of the ordinance, a woman would also cover a man. And so if the sexual harassment is man to man, man to woman, and vice versa, and woman to woman, they're all covered. All right, man to man. Is an offense if the elements are involved. So we don't believe it is necessary to amend the ordinance. Of course, Mr. Ho talked about the third sex. However, in Hong Kong, we have not reached that stage. As regards future development and the public consultation being conducted by the EOC, they can be considered in the future. But at present, our sex discrimination ordinance covers this scope, and I think this is sufficient. After Mr. Ho's reminder, I've discussed with the DOJ and come up with this conclusion. And the second question is if within Hong Kong, whether it be a Hong Kong resident or tourist visitor, if there is a sexual harassment act, we do have jurisdiction to control that. That's right. On international flights, for instance, there's the opportunity of a third sex on the plane, and if the harassment act is against that person, then he may not be protected by the law. Well, can you amend it to change to sexually harass a person, and that will address the problem? I've asked the DOJ to study this issue. Perhaps they can supplement now. DOJ? Ms. Ho's question relates to the recognition of the third sex in our law. So far in Hong Kong, we give recognition to two sexes, male and female. A third sex would involve a more complicated issue, and we are still studying that. All right. Ms. Helena Wong. Thank you. I'm pleased to see that finally the administration has introduced this bill to the Council. A series of anti-discrimination legislation was passed before the handover. And for this ordinance, it prohibits the service provider to sexually harass a customer, and women groups are very unhappy, and they've been asking for an amendment for more than a decade. Finally, we have this meeting, and the bill is welcomed by the women associations as well as the DP. In fact, the bill is long overdue. And Ms. Sidho raised a point just now. We want the bill to improve our current legislation to widen the scope of protection offered by the bill. With the bill passed, the majority of practitioners in service trades in Hong Kong will be protected. And there is also protection for hostesses and stewards on Hong Kong registered aircraft and ships. However, we're only able to catch Hong Kong registered ships and aircraft under this bill. I'd like to ask the administration whether you have statistics on the number of employees in our service industries working on board ships and aircraft, and including those registered in Hong Kong and those not. Can you tell us and give us a ratio between those registered in Hong Kong and those not, so they'll be able to know the percentage of employees we can protect, and is there any scope to further extend the scope of service industries covered by the bill? Thank you. According to information from the Transport and Housing Bureau, according to their information, there are about 10,000 or so employees working on Hong Kong registered aircraft, but we don't have any information for aircraft not registered in Hong Kong. Our estimate is a few thousands, according to our exchange with the trade unions. And for ships, we don't have any idea about the number of employees providing service on ships. I hope you can give us statistics as accurate and scientific as possible. I think they have their trade unions. Perhaps you can consult them. Even though you don't have not the exact figures, give us the rough idea. For local airlines, over 12,000. Give us a paper, please, so that there can be clear statistics for us to understand how come you don't have information for ships. How many registered ships do we have in Hong Kong? The crew may not be employed in Hong Kong. We will follow up with the THB to see whether it has got such information. For passenger ships, the crew is usually recruited globally. It's not like aircraft. THB knows that there are about 12,000 members of the crew on Hong Kong registered aircraft. We have a big cruise terminal. I'd like to know whether there are ships registered in Hong Kong visiting the terminal. Let us follow up because we don't have the information with us now. Yes, Chair Lady, please help us to pursue the information. I think there should be some information for instance, for liners. They will tell us the number of passenger, the capacity of a vessel, and also the rough ratio of the crew and staff working there. Okay, I'll ask the Secretariat to follow up for us. And whether it is possible to extend the application to non-Hong Kong registered ships and aircraft. Is it because of our limit in jurisdiction that we cannot do it? What if we have local employees working on non-Hong Kong registered ships and aircraft? If we cannot cover them in this bill, where else and how can we help them? The current amendment has expanded the scope of the bill. In the past, it is an offense for a service provider to sexually harass a customer. And in the past, the law would not apply to Hong Kong registered ships and craft while outside Hong Kong. This time we have covered them. But these vessels must be registered in Hong Kong. For vessels registered in other places, they are subject to the jurisdiction of the respective place. This is our limit. Supplement. If aircraft registered in Hong Kong, outside Hong Kong, is involved in such an offense in Hong Kong, we have jurisdiction to catch that act. Now, you are talking about an airplane or ship registered outside Hong Kong, and on board a Hong Kong resident has been sexually harassed, and he is still protected by the law. Is that right? Well, if the crime happens in Hong Kong, regardless of the nationality of the victim and the accused, they will be caught by the bill. Within Hong Kong, what if he just wouldn't disembark? Well, even so, because the plane is in Hong Kong, then we still have jurisdiction. Okay, Mr. Kok Wai Keung. I have a number of questions to ask. The Undersecretary told us that mail would be covered, but I don't see any reference to mail in the bill. I only see the term woman. So I'd like to ask the legal advisor whether a similar approach is used in other ordinances. While it says a man, while it says woman, a man is also covered. And para 8 says there have been 2 cases of sex bill of sexual harassment in half a year's time. I'd like to know whether that's the only cases you have, and I'd like to know whether sexual harassment would only mean verbal abuse. What about there's been a physical sexual harassment? If yes, shouldn't you include cases of indecent assault while at work, so that we know the total number of sex abuse and sexual harassment? Because according to your paper, there have only been 2 within half a year, and that may not be the reality. Now, to follow up on Dr. Helena Wong's question, well, if the ship or airline is inside Hong Kong, of course you have jurisdiction, but it keeps moving. How can you confirm whether it is inside or outside Hong Kong?
Now we are concerned since, for example, there is a flight departing Hong Kong to Mexico. It's just an example, right? Mexico. Then, if the air hostess makes a report, then that person may be arrested as soon as he arrives in Mexico. But can the air hostess also make a report in Hong Kong when she comes back, or what? All right, 4 questions have been raised. Let's see whether our legal advisor can address his concerns. Yes, Chairman, firstly, now I want to say that concerning the racial discrimination ordinance, disability discrimination ordinance, and the family status discrimination ordinance, neutral gender wording is used, but then in this one, this is not the case. And then concerning sexual harassment provisions, it is said that males are offered the same protection as females. And that will cover sexual harassment by someone from the opposite sex or from the same sex. So how come you can't say males and females? Now, I think it's just a matter of drafting style. Perhaps the administration can supplement. All right, D of J, please. Yes, Chairman. Concerning the sex discrimination ordinance, this particular drafting style has been adopted. In the interpretation section, it says, although the female sex is used, the same protection is given to males. And that's why we've also adhered to this drafting style. Right, concerning the remaining questions, perhaps they can be dealt with in the second round. Perhaps I can assist here. Yes, if you want to ask questions, you can do so in the second round. But perhaps I can assist in answering this one. Chairman, can you allow me to give an answer now, because I'm worried that I may forget the question. So do members agree? Ms. Sit-Ho agrees. No, I'm just indicating that I want to queue up to ask questions. And Chairman, as we don't have too many members here, please do not impose the time limit of 5 minutes. All right. Also, I'll accept your suggestion, Ms. Sit-Ho. So in principle, each member will have 5 minutes. But I'll not be too rigid, because if one member gets only about 5 minutes and the other member gets 10 minutes, then members may complain. All right. Under Secretary, please. Yes. Let me give a brief reply. Mr. Kwok wants to know whether sexual harassment covers only acts and language. Now, if you look at Section 2.5 of the Sex Discrimination Ordinance, you know what sexual harassment means. And then indecent assault, yes, we can obtain the figures from the police for members' reference. And then as to whether the ships or aircraft is outside Hong Kong or not, in the past, for sexual harassment occurring in Hong Kong, of course, Hong Kong had the jurisdiction. But then what about an aircraft? What about sexual harassment on an aircraft outside Hong Kong? And then if the act is in another jurisdiction, then of course our laws cannot cover that. But now we are amending the law, so that if someone is sexually harassed in another place, then he or she can come back to Hong Kong and complain to the EOC or make a report. So in fact, the amendment seeks to deal with an inadequacy in our legislation. Mr. Poon Chiu Ping. Mr. Poon, yes, I also want to ask about sexual harassment cases outside Hong Kong. I understand that you're talking about Hong Kong registered ships or aircraft. And the law applies if the ships or aeroplanes are outside Hong Kong. Now there are the so-called gambling ships or casino ships, and sometimes they are in Hong Kong waters, sometimes outside Hong Kong waters. They may not be registered in Hong Kong, but then many Hong Kong people do work on these ships. So is it that whether the ship is registered locally or not is not important? I just want to clarify this point. Or is it that where the ship is registered is a very important consideration, Under Secretary? Now, irrespective of where the ship is registered, if it is in Hong Kong, then of course this piece of legislation applies. And then if a ship is registered outside Hong Kong and the ship is also outside Hong Kong, then this piece of legislation cannot apply. So if a gambling ship is not registered in Hong Kong, and if there is sexual harassment on the ship and the ship is outside Hong Kong waters, then we can't deal with the case with this bill. Now, if the ship is registered elsewhere, then it depends on the law in that particular country. If in that particular country the law is the same as what we are proposing in the bill, so the Act will be dealt with in accordance with the law of that particular country. So, Under Secretary, if the ship is not registered in Hong Kong and yet the sexual harassment occurs in Hong Kong, in other words, the ship is in Hong Kong, then the victim can make a report to the police or seek assistance from some other organizations. Yes, correct. Mr. Chen Chi-Chun, I've got a few groups of questions. The first group relates to Ms. Sit Ho's question on the third sex. Ms. Sit Ho said she suggested that the administration should consider her proposal. Now, say there is someone with gender X stated in the passport, and if this person sexually harasses another person, or if this person is sexually harassed, then does it mean that this person will not get any protection because this bill only protects males or females? So what if, according to the passport, this person is gender X? Yes, D of J, please. Is it that for a person of the third sex, this person won't be able to get any assistance? This is a rather special situation, Chairman, and there may be uncertainties concerning the application of this of these provisions, because there is this wider question of the recognition of the third sex. And under the laws of Hong Kong, only two genders are recognized, males and females. But I understand that a study has already begun on the recognition of the third sex. And the police will be looking at all the ordinances in Hong Kong. Now, I just want to say that members need to be aware of this limitation in the bill. But Mr. Chan, in fact, this is the case with all ordinances, and so they've begun a study, and so they may implement a new measure from a certain date. Yeah, I know all these, but I just want to say that this bill can't cover the third sex. And then how come you can't say if anyone sexually harasses another any person sexually harasses another person? Is it that if we do not mention the genders, then that would no longer come under the sex discrimination ordinance? What's the difficulty? How come you can't say if any person sexually harasses another person, that will be an offense? Now, D of J. Now, because we are only adding certain clauses to the bill, we need to still follow the principle adopted. If we, in the amendment, adopts a different approach, then there would be an unclear situation, and that's why we need to follow the principle of interpretation. So in fact, it's just a technical difficulty. So in fact, they want to do it on a one-off basis, and they've begun the study. Chairman, concerning sexual harassment under the SDO, is it a civil offense only? But of course, indecent assault is a criminal offense. So for sexual harassment under this ordinance, is it that there will be either the parties will go to court, or there may be conciliation? So is this of a civil or a criminal nature? Chairman, Mr. Chen Chi-Chin's understanding is correct. It's basically a civil offense. Concerning indecent assault as a criminal offense to be dealt with by the police and not the EOC. But then sometimes it's difficult to differentiate between the two. Now say there was a chef who patted the buttocks of a waitress, so, and that case was dealt with under the SDO. But wasn't that indecent assault? Maybe only the legal experts can enlighten us on this. If you can't give a reply today, you can give a reply next time as to what amounts to a criminal offense. So is it that it can be a criminal offense, and yet the case can also be dealt with under this ordinance, and compensation can be sought?
DOJ, well, under the SDO, sexual harassment is a civil tort, and indecent assault is a criminal offense. The burden of proof and the standard of proof is different. For criminal offense, it is beyond a reasonable doubt, and the standard of proof in a civil case is relative probability. And any indecent assault against another person is an offense and is indictable and liable to imprisonment of 10 years. And for sexual harassment, first there's a complaint to the EOC, or the person can also seek a civil claim against the accused. And according to experience, there can be various forms of mediation. There can be a settlement in the form of money, and another is undertaking not to repeat that again. And according to our understanding, it can be a civil claim, and if the criminal element is sufficiently strong, the case can be taken up by the police. A follow-up. I'd like to know whether the two can be done in parallel. Now, if I decide to prosecute a person for indecent assault, I can still seek a civil claim, or are the two mutually exclusive? Mr. Chen, our understanding is the two can be done in parallel. Thank you. Can be done in parallel. Enough protection. Next, Mr. Zhong, Kwok Pan. I'd like to follow up on Mr. Kwok Wai Keung's question. Now, if it is outside Hong Kong and a person has suffered a sexual harassment done by a foreigner, and he has already left the airplane overseas, and even if the air hostess comes back to Hong Kong to complain, what's the point? What's the use? That means the law cannot protect our air hostesses. And for a Hong Kong registered ship or airline or a plane in Hong Kong, if a foreigner has been sexually harassed, can he complain as well, or will the law just protect Hong Kong residents? Two questions. First, I think Mr. Chung has pointed out a valid point. If a air hostess is on a Hong Kong registered plane, and then in another country she has been sexually harassed, and the culprit has already left the plane, so even if she comes back to complain, the person cannot be traced. Now, there are two possible ways of dealing with it. The air hostess can make a complaint when they are overseas. If the place has jurisdiction on this, then she can complain, and the case will be taken up there. And for a passenger on an airplane, well, there is the record of passengers, and there is even CCTV. Unless that a person never returns to Hong Kong, nothing can be done. But if he returns, then he can be arrested. So the important thing is we have the name of the passenger. Well, because this is a civil case, even though the air hostess has lodged a complaint and the case is filed, but even if the passenger comes back to Hong Kong for a couple of days, there is little you can do, even if you have his name. Can something be done? I think Mr. Zhong's case indeed means some difficulties in a civil claim. Perhaps our colleague can supplement. Now, if the sexual harassment takes place outside Hong Kong, then we cannot ask another government to enforce the law for our behalf. But then under Section 72 of the SCO, we can ask our court to seek legal assistance from their counterpart, and can seek the assistance of a foreign court to take a statement or gather evidence on our behalf under Section 76 of the SDO. Will only Hong Kong residents be protected, or any foreigners in Hong Kong if the incident happens in Hong Kong? if the act happens in Hong Kong, regardless of the nationality of the persons concerned, they are covered by the bill. So long it is within Hong Kong, or maybe a Hong Kong registered plane flying away, and a foreigner on the plane is still protected. Yes. Next. Now we have completed our first round. Second round. First, Dr. Hannah Wong, and then Ms. Sid Ho, and then Mr. Ray Chen. Yes. Dr. Hannah Wong. Thank you. Chairman, please consider the following. Because the EOC is the statutory body set up to enforce the sex or the discrimination legislation. So I hope we can arrange for the chairman of the EOC to discuss with us. Let us have their expert advice in the light of their experience in dealing with sexual harassment, and see whether they have got any suggestions for the bill. And Chairman, I hope you can arrange a public hearing to invite trade unions and associations of employees in service industries, and also invite women groups. For more than a decade, they've been fighting for the bill to be amended. And we can also invite NGOs and people interested, scholars and researchers in this interesting topic. I hope with their input we can improve the bill to better take care of the interests of stakeholders. I know many members are going into vacation. I hope the public hearing can be done in sometime in late September. I'm happy to see that we're going to apply the ordinance to Hong Kong registered ships and aircraft while outside Hong Kong. But I think there is a major omission here. You talked about ships and aircraft, but what about roads? What about cross-boundary coaches between Hong Kong and the mainland, the minibuses, the light goods vehicles and buses? Given the very busy traffic between Hong Kong and the mainland, how come for mainland-bound tours, if there is any sexual harassment on board such a vehicle, how come they are not covered? Why have we this major omission? Now, if we use this concept of places inside Hong Kong and also other countries, and then in between is no man's land. Now, our amendment seeks to cover the area during the journey. And now for vehicles, for land vehicles, there is no gap in between. Either you are in Hong Kong or in the mainland. Well, so long as you are in the mainland, you are subject to the rules and regulations of the mainland. There is no gray area. So we've not included Hong Kong registered vehicles or our railway, our trains. The important thing is in whatever jurisdiction the persons are protected. For road traffic, there is no such vacuum as vessels and aircraft. Will you, Chairman, will you bring along a Chairman of the EOC to the meeting? There is no need for the administration to initiate that. Chairman, you can issue an invitation through the Secretariat. You do have that power. There is no need for the administration to consent. It is our work. All right, I will discuss with the Secretariat so that we can invite them to our next meeting. What about meeting deputations? Well, this is our next agenda item. Okay. And can the administration further clarify? According to the administration, for road traffic, there is no vacuum on the road where no jurisdiction applies. I'd like to know whether on the mainland they have a similar protection for service providers. Do they have legislation, a law to protect service providers from sexual harassment? If there is none, then what about our tour escort and our tour guides? If they've been subject to sexual harassment while on the coach on the mainland, is there any law on the mainland to protect them? DOJ, please. We will study whether there are similar provisions for protection against sexual harassment on the mainland. Yes, please give us a paper next time. Chairman, beg your pardon. I asked about the number of service providers working on ships and aircraft. And I also like to know the statistics for service providers on road traffic, whether they are tour guides or tour escorts. I'm talking about people in this industry because they lead tours into the mainland from time to time. Well, they told us it's 0.6 million. I hope we can have it on paper because it is a serious matter when it comes to the scrutiny of the law. All right, I'll ask my colleagues from THB to check. Ms. Sitho. Thank you, Chairman. First, I have to seek a clarification with the DOJ. We want you to amend the bill to say unlawful person to sexually harass another person. I'm not asking you to recognize the third sex. Rather, we want you to be flexible so that you can cover everyone. Because a person of the third sex is still a human being and is recognized by their own country, its own country. So you should not say, we're not asking you to, it is unlawful for a man or woman or of a third sex to sexually harass a man or woman of a third sex in the course of blah, blah, blah. Since we are a world metropolis, there is no reason why we should not cater for such things. This is different from local legislation to recognize the third sex. And please do not mix up the two things. We're asking you to be flexible. If we have the majority support of this BC, then our chairman, you can move such an amendment on our behalf. There is no charging effect, and I don't think will be caught by Article 74 of the Basic Law unless the Undersecretary says so. If yes, then we can argue. We can debate, and it will become a constitutional issue. And for the definition of aircraft and ships, because in English you say local ships and aircraft, and in Chinese, local also aircraft and ships.
But in other pieces of legislation, there is the term Hong Kong controlled aircraft. And then there are a series of definitions. For example, registered in Hong Kong, main business in Hong Kong. Then that's 494. So how come you're not using this term here? There must be a reason behind this. So are we talking about the same aeroplanes? Because 494 says Hong Kong controlled aircraft. In other words, not just aircraft registered in Hong Kong. So you say here the main business is in Hong Kong, or the operator has close ties of Hong Kong, and so on and so forth. And if the scope here is narrower, then my question is why? DFJ, please. Mr. Ng. Yes, thank you, Chairman. Concerning ships and aircraft, I want to say that similar wording is used in the discrimination related ordinances. And then concerning the definition of Hong Kong controlled aircraft, I believe the member is referring to the Aviation Security Ordinance Section 2. Now this ordinance is another ordinance with separate policy considerations. And so the definition that suits the policy intentions is used. Yes, there is this definition. There is another definition under the Hague Convention. You said there were separate policy considerations. What are they? Unruly behavior, and then unruly behavior versus sexual harassment. And which one is wider? Which one is narrower? I mean, Hong Kong controlled aircraft and locally registered aircraft. So can you give us a paper on the scope and the definitions? Hong Kong controlled is very different from locally registered or local. So can you give us a further reply next time? Chairman, I may not disagree with them, but I just hope that the DFJ or the Policy Bureau can give us all the information so that we can make an informed decision. Right? Mr. Ng? Is that agreeable to you? Chairman, thank you. Now the definition depends on the policy consideration. So it's really a matter of policy. But perhaps you can reflect the members' concern to the Bureau. So does it mean that the Bureau should be answering the question? Yes, of course, I understand that that is the Aviation Security Ordinance. This is the SDO. But you can't simply tell me that the difference is because of different policy considerations. What policy considerations are there? So are you saying that the Bureau should give you a reply? Let them decide on the division of labor. So which one is wider? Which one is narrower? Hong Kong controlled or local? And then what are the different policy considerations behind using two different terms? I think you can ask them to look at the wording, and then they will give us further replies next time. Let's continue. Chen Chi-chun. Mr. Chairman, I understand that the amendment seeks to cover sexual harassment occurring outside Hong Kong. But then I think Ms. Helena Wong has tried to clarify this point concerning local ships or aircraft outside Hong Kong. After the amendment, we can only cover sexual harassment in international waters or airspace. Does it mean that if the ship or aircraft is in the waters or the airspace of another country, then the laws in that country will apply? Now, I think we can look at three types of scenarios. First scenario, within Hong Kong. Second scenario, international waters. Then third scenario, the jurisdiction of another country. And I want to say that the amendment seeks to cover all three scenarios. In other words, the aircraft is in Hong Kong. Second, the aircraft is in international airspace, and then before the aircraft lands in another country, then the person can choose to complain in Hong Kong or in that particular country. So in other words, the person can come back to Hong Kong to complain. So Ms. Helena Wong mentioned the express rail link and the coaches. What if there aren't similar provisions, legal provisions in the mainland? So the person can come back to Hong Kong to complain. Is that right? I thought you were trying to deal with the second scenario, in other words, international waters, international airspace. But then on land, there's no space called international land. So it's either Hong Kong territory or mainland territory. So, and then when it comes to the third scenario, even if the victim hasn't alighted the aircraft or the ship or the coach or the train, he or she can only seek help under the laws in that country. Is that right? And do we have such provisions in the mainland? But because, as you know, well water cannot try to infringe on river water, as the saying goes. Yes, we will go back and look at the regulations in the mainland. But I want to get some legal advice. What if can the amendment also cover the land? So can this be done? And then I want to ask this question. These provisions also apply to sexual harassment by a person of the same sex. I want to know whether you have the number of previous cases in this category, and do you have the amount of compensation or remedy that you can give to us. So in fact, I want to have the figures for cases dealt with under the SDO. Some cases went to court, some cases were resolved through conciliation. But want to know whether the administration has got statistics on the previous cases and the compensation amounts. Yes, Chairman. 1st of January 09 to 2014, 31st of January, the EOC received 500 sexual harassment complaints. And then concerning males, sexually harassing males, about 8 cases. And then females, sexually harassing females, about 10 cases. And then there were cases resolved through conciliation, and compensation was paid. But then we tried to obtain some figures from the EOC, but then there weren't too many cases, and you know, there were privacy considerations. But I understand that for some cases, the names of the restaurants, for example, were made public. Those cases went to court. Oh, what about cases dealt with through conciliation? In some cases, compensation was paid, and then in some cases, investigation was terminated. So can I ask the administration for more detailed information and figures? So you're talking about 4 scenarios. Males harassing males, females harassing females, males harassing females, females harassing females. You want to know how many cases there were in all these categories, and whether the cases were resolved through conciliation. So is it that you only have figures from the EOC? Yes, and then some cases went to court, and as a result, the employers' names were disclosed. The penalties were also made public. So can you give us some such information? And then cases resolved through conciliation. Do you also have the detailed figures? Now, males harassing females, 195 cases. Males harassing males, 8. And out of the 8 cases, 2 cases were resolved through conciliation. 2 cases could not be resolved through conciliation, and then 4 cases. In 4 cases, investigation was terminated because of insufficient evidence. Females harassing males, 5 cases.
And males harassing females harassing females, 10 cases. 1 case with a successful settlement with cash compensation. 9 cases investigation terminated because of lack of confidence of evidence. What about court cases? We don't have any with us. Males harassing males or females harassing females. No court cases according to the EOC, but whether they have done that themselves, I don't know. The explanation is a bit clumsy. I didn't get it very clearly. Please give us a paper. Well, he was very clear. Then can you repeat it to us? male against females 185, males against males 8, 2 successful cases, 2 failure cases, and 4 unsubstantiated, and females against females 10 cases, 1 successful compensation, 9 unsubstantiated. So I think we should have such information maintained, the records kept. I hope there can be improvement in males harassing females. There are 195 cases. I think there will be more cases in the future because in the past, sexual harassment by customer to service providers were not covered. All right, and what's the problem? Well, I just want to tell you that there will be more cases in the future. So Mr. Ray Chen got 10 minutes. All right, any more in the second round? Oh, the first round. Mr. Paul C. Thank you, Chairman. We would like to include to enhance the coverage of the bill to cover sexual harassment to service providers. In the past, there was only protection for customers. However, we only talk about ordinary service provision. What about in the education scene? If a teacher sexually harasses students, that is covered, and sexual harassment by a member of the management, there is protection for occupiers, but not the other way around. But here, the bill only involves provision of services. But what about cases like relationships like a teacher and students, and trainers and trainees, and management of a unit and the occupiers? It appears that the current amendment doesn't cover this. Is my understanding correct? To only cover service providers? Yes? Thank you. In the law, for instance, Section 24 of the SDO includes provision of service provider of training facilities to trainees, and Section 39 in education sector, staff of an education institution, that is teachers, sexually harassing students, and students harass students, and also manager of a premises harasses an occupier. This bill covers mainly service providers. And has also extended EOC's proposal to cover Hong Kong registered ships and aircraft while outside Hong Kong. You don't have to repeat. Why don't you cover a student harasses a teacher, and occupier sexually harasses the manager of premises, and so on and so forth? The EOC is conducting a review of the anti-discrimination ordinances, and one of the topics of public consultation will cover your concerns. Then why don't you amend them in one go? Is it that in real life there is no student harassing a teacher? The EOC is consulting the public. It will review the relevant legislation and make recommendations to the administration. After their public consultation is over, and if they have analyzed their views, we will consider their recommendations. I understand you have priorities, but I'd like to know why you have picked only these areas in the current amendment and not others. Undersecretary, Mr. C's observation is correct. In the SDO, there are many scenarios, and sometimes the offense is will cover both sides. And in some areas, we will also consider whether a discrimination on the basis of sexual orientation will be covered. So one option is to wait for the public consultation or the review to be completed before we introduce this bill. This is one option. On the other hand, customers may sexually harass service providers. Many employees are suffering in service industries such as people who are nurses, airline hostesses, waitresses, beer promoters, and saleswomen. So there are a lot of complaints, and we have decided to amend the bill in this way first. For the other areas, we will await EOC's public consultation and recommendations, and will consult members before we proceed. We believe this is pragmatic. In the past, if a customer was sexually harassed, if the employer had not made any measures for the employees, then he had some responsibility. Now, in this case, what is the responsibility of the employer? Is he required to make measures or policies to ensure that the employees will not be sexually harassed by a customer? In the past, if an employee sexually harassed a customer, the employee was held liable because of this employment relationship. The employer had to ensure that training and arrangement was such that the employees should be warned. But if it is the other way round, the customer and the employer is not related. There is a contractual arrangement. The employer can choose not to serve that customer. Yes. But there is no direct contractual relationship between the customer and the employer. No, the two are related. The employer has to ensure that the customer is well protected, and there cannot be any infringing act on service providers. So you should consider the employer's responsibility in ensuring that his employees will not be subject to sexual harassment by customers. Yes, we have considered this. We have also considered overseas practices. There are different ways. Some share our current rationale. Because of a difference in relationship, the employer is not held liable. And in some cases, the employer has to shoulder some degree of responsibility. And there are countries who had the responsibility to protect their employees, but recently, as in the UK, they have given up on that approach. So in Hong Kong, we have to consider our local circumstances. The employer, and if we are to include the employers, we need a consensus from employers first. Yet, we don't have such a consensus, and employers may have concerns. So in this round of amendment, employers are not covered. So please consider this, and when you have another round of amendments, please consider this possibility. Mr. Tan Kapiu, you referred to labor unions, and what industries have you covered? For instance, members asked about tour escorts and tour guides, and the moment when they will be protected by the bill. Now, even if the persons have not left the plane, but it is already on foreign territory, will people still be protected? And if they have left the plane, and if they are subject to indecent or impoliteness from their customers, is it true that they cannot be protected? Yes, thank you. Because the proposal is from the EOC. And through the EOC, we have met with relevant stakeholders. The Association General Alliance of the Labor Unions, and also representatives from CX, and the trade unions from CX, Air Dragon, and also employers, representatives from the Association of Bars, and we met them together with the EOC to explain to them our thinking. But back then the bill was not yet drafted. We explained to them our concept and what if the harassment takes place on a plane, and once the relevant persons have left the plane, then it would depend on whether there is protection in the law of the relevant territory. So if a Hong Kong tour escort leads a tour onto the mainland, on the plane, the customers are polite enough, but when they are visiting places in a coach, the customers are no longer polite, so the tour escort would not be protected. Now, for tour escorts, they will go to places all over the world. I thank you for consulting the major trade unions, including the FTU. But I think tour guides and tour escorts frequently accompany visitors or tour groups, and they have to solicit tips from their passengers or their tour members. So perhaps you should consult the trade union of tour guides and escorts. What if a Hong Kong tour escort leads an outbound tour? If I'm injured in the course, I am protected by the employees' compensation ordinance, right? For instance, if I lead a tour group to Guangzhou to play to visit, I encounter a car accident, I will still be protected.
Yes, first of all, I wish to clarify one point with Mr. Tan, and that is what has the receiving of tips by tour guides. What is the relationship between that and this bill? Now, because these people do not receive a fixed amount of salary for outbound tour guides, they a large part of their salary is the tips from the customers. And what if the tour members say, I'll give you more tips, but then let's get closer together when we take the photos. So it's my worry unnecessary. And then if a tour guide is or is injured when he is on duty outside Hong Kong, then he'll get compensation. This is a principle. Why can't this principle be reflected here? Now, Chairman, now I understand. Now, for a tour guide, whether he receives tips from the tour members or not, and whether he has to tolerate certain acts by the tour members. Now, I think that's not the crux of the matter. In this bill, we cover sexual harassment occurring in Hong Kong or occurring on aircraft, on ships, and then concerning the land border, we've promised to look at whether in the mainland they have similar regulations. Now, I want to say that, in fact, there are many Hong Kong laws that can't be extended to other countries or the mainland. So we will now mainly look at aircraft or vessels outside or ships outside Hong Kong. And then concerning the land border, of course, it's either Hong Kong territory or mainland territory. And we will report back to members next time as to whether there are similar provisions in mainland law on sexual harassment. And then as to whether we have consulted the tourism industry, now, I understand that there will be a hearing in the Spills Committee, and I'm sure it will be helpful if we can, during the hearing, listen to the views of different sectors and industries. Mr. Kwok Wai Keung. Second round, Mr. Kwok Wai Keung and Mr. Tan Kah Pew. Mr. Kwok, please. Thank you, Chairman. Chairman, the amendment seeks to protect the employees. In other words, not only the customers. Of course, we support the amendment, and we hope that the amendment can be effective and can be wide enough in its scope and coverage. And the Bureau has told us that sexual harassment cases have been dealt with mainly through conciliation. I want to ask whether the EOC can punish the offenders. Is it that conciliation is the only or the main way to deal with such cases? And is it that other procedures are cumbersome and complicated, and as a result, many people have opted for conciliation? Yes, thank you, Chairman. I thank the member for his questions. Under the SDO, any person who feels that he or she has been sexually harassed can institute civil proceedings. Concerning the conciliation figures, now, I just want to say that under the 4 discrimination ordinances, persons who feel aggrieved can complain to the EOC. So people who feel that they are discriminated on the ground of sex, race, family status, disability can complain to the EOC. The EOC carries out investigation into these complaints, and the EOC will suggest conciliation. But of course, if conciliation is considered unacceptable, or if conciliation doesn't succeed, then complainants can resort to other procedures or seek other forms of assistance. So the EOC carries out investigation and suggests conciliation in all cases involving the discrimination ordinances. Now, of course, I think civil proceedings is the best option. So this ordinance is like the defamation ordinance. There is the ordinance, there are the penalties, there are the offences, but then it's very difficult to have a successful prosecution. And I think few victims will institute civil proceedings. They would rather opt to complain to the EOC, and then they will decide whether to institute civil proceedings. But then the EOC usually suggests conciliation. And I understand that remedies or compensation may be paid to the victim, and as a result, the victim can no longer institute civil proceedings. Is that right? I understand that some people say that they prefer conciliation because the matter can be resolved very quickly. Conciliation is also cheap. Conciliation takes only 1 or 2 days, and also the waiting time for conciliation is short. And many people prefer conciliation because when the case goes to court, the court will rule either in his favor or not in his favor. But then a conciliation may result in a win-win situation. All right, I'll let the Undersecretary give a reply. Now, Chairman, I think we can ask the EOC to explain the situation to members, and then we can also give our response later. Mr. Tenkapil, also in the for the second round. Chairman, I hope that more can be done to address the concerns of the tourism sector. and of course we do support the bill. And then males harassing males, males harassing females. Now we want to have a more detailed breakdown, because you said there were a total of about 500 cases, but then concerning the breakdown you have just given us, the total doesn't add up to 500. Hong Kong is the 4th largest territory in terms of the shipping register. But then there are ships carrying people to the international waters for gambling. And then there are also vessels, cruises, taking people for a tour, say lasting for 5 to 6 days. So these vessels may not be vessels registered in Hong Kong. For example, they may be registered in Singapore. Yes, I understand that we have a very big shipping register, but can you confirm this for me, please? Is it that many of these vessels we see in our harbor are registered elsewhere? And I understand that from next year onwards there will be a lot of cruises. They will use Hong Kong as the home port. So and how can we protect the people working on these ships or vessels? Under Secretary. Now, irrespective of where these ships are registered, if they are in Hong Kong, for example, if they are at a cruise terminal, then they will be covered by Hong Kong laws. And then for ships registered outside Hong Kong, say Singapore, Singapore may also have similar laws to deal with such situations, and maybe that country doesn't have such laws, and then there may be a problem. And Mr. Tang is asking us whether we can cover such a scenario in the bill, but it will be very complicated or even impossible to cover ships and aeroplanes registered in other countries. So this is already an improvement. So we are mainly talking about locally registered ships. And for staff on aircraft, in fact, I believe 80 to 90% of them will have been covered. When I was small, I traveled on cruises with the stars as their names, and I understand that many of them are registered in Singapore. Say, for example, at the cruise terminal on Canton Road, Tsim Sha Tsui. Can we know how many of these ships are registered locally and how many are registered outside Hong Kong? We want to know whether those working on these ships will be covered, but is that very complicated? Yes, if the member wants us to collect such information, then we will try our best. So you are talking about Tsim Sha Tsui, right? Ocean Terminal. For example, the ships buoyed there are berthed there in 2013. So we'll try to ask about the places of registration of the ships berthed there in the past year.
Second round or third round? Dr. Hannah Wong and Mr. Ray Chen. Well, we still have time, so 4 minutes each, okay? 4 minutes. Dr. Anna Wong, I have a clarification and a question in relation to Mr. Paul C's question. If in an education institution, if a student harasses a teacher, is the letter protected or not? The answer I got seems to be no, but regarding the SDHO enacted in 1993, Section 39, under Section 39, anyone from the education institution cannot sexually harass a student, nor can a student sexually harasses another student. But if it is the other way around, it is still outlawed. A student cannot sexually harass a member of the education institution. So everyone is protected, but for service industries, there is an omission, and therefore the amendment seeks to address that gap. So for an education institution, anyone from the management or staff of the education institution should not be subject to sexual harassment by students. And for a ship and also airplane, if the bill is enacted, then everyone is protected while the journey is carrying on. Now, if the offender is not a Hong Kong resident and he has sexually harassed another person on the plane or ship, will he be extradited back to Hong Kong? Will be invited back for conciliation, or will it be by video conferencing, or what? How can we ask the perpetrator to be responsible? I think Section 1 already covers all scenarios, male to male, female to male, female to female, and female to male. I think the first part of the amendment has covered everything. Chairman, you have used my time. I can return it to you. You have spent my time to answer questions. Your duty as the chairman is not to answer questions on behalf of the administration. There is no need for you to interpret our questions. All right, Undersecretary, or rather, the PAS. Thank you, Dr. Wong, for your questions. We have sought the advice of the DOJ, and according to them, a sexual harassment act that takes place outside Hong Kong can be dealt with in two ways. Assuming that there is similar legislation in the place concerned, assuming that it is in Australia or the UK or Canada or the US, the victim can make a complaint to a similar organization, to the EOC. And another option is for the victim to come back and seek help from the EOC. Another option is to directly initiate a civil proceeding with the district court. And according to the DOJ, once the case is accepted by our court in Hong Kong, under Section 76 of the SDO, well, evidence has to be submitted. Then the court can invoke the relevant convention or treaty or under mutual legal assistance principle, seek help from the court of the relevant place. Now, I don't have the legislation with me, but the court can seek help from its counterpart in the other territory to gather evidence. This is quite critical because this is about how the bill can be enforced after enactment. So please tell us how it will operate. How can a victim seek redress? Will extradition be needed? And because the perpetrator is not a Hong Kong resident, he is not in Hong Kong, and how can he be traced? And on a coach, if the perpetrator is a mainlander, now assuming that there is a similar piece of legislation on the mainland, how can the victim seek redress? I want a reply in writing. Just a minor point. For civil proceedings, there's less likelihood of extradition. Extradition is for serious offenses, criminal cases. In fact, many countries have relevant legislation against sexual harassment by a customer to a service provider. So if there is a similar piece of legislation there, then the most expeditious way is to lodge a complaint there. All right, Mr. Ray Chen. All right, you have expanded the scope of the bill to cover employees. And I think Mr. Posey has mentioned a very critical point. After the bill is enacted, will there be increased responsibility on employers? Because in SDO, if supervisor sexually harasses and subordinate, usually the former may have to resign, and the employer has to pay huge compensation to the victim. Now, we don't have representatives from employers here, but according to the administration, there is no responsibility on the part of the employer in this bill. But I share Mr. Posey's view that the employer has some responsibility. Let's say the customer comes every day and he is a big spender, and can I sue the employer because he has allowed that customer to come every day or repeatedly, although he has sexually harassed me? So please confirm whether the bill will put more responsibility on employers. Members representing SMEs should be concerned about this, because the employer may be liable to pay compensation, and he may have to take reasonable steps of due diligence to ensure that his employees are protected. Mr. Lau, in my exchange with Mr. Xi, I said that this bill will not cover responsibility of employers, though Mr. Posey said that we should have included enhanced responsibility on the employer. And I think what Mr. Ray Chen said is very fair. We need to seek the views of employers if the bill involves enhanced responsibility on their part. But as I said, we must have a consensus with employers first, and they may look at this issue with a different perspective. So whether it be from this Bills Committee or from deputations, I hope to have more views on this point. But we have considered experience overseas, and we've also considered our local circumstances, and we have no intention to include to enhance the responsibility of our employer. So your policy intent is not to enhance the liability of employers. Yes. The fourth round, Dr. Helena Wong and Mr. Tan Kapil, but Mr. Posey asking questions for the second time. All right. Can we continue in the next meeting, because we're scheduled to end at 10:30 and we still have other business to deal with? Can we leave it to the next meeting? All right. All right. Since members are so eager, I am going to extend this meeting by 15 minutes. 15 minutes. Are you awake? All right. Mr. Posey speaking for a second time. Do we have any more members and speaking for the second time? Anyone speaking for the third time? All right. For the fourth time? For the third time, Mr. Tan Kapil. And for the fourth time, Helena Wong and Ray Chen. That's it, okay? Mr. Posey, you go first. In response to the Secretary's reply, I'd like to say that Section 46 has this precarious responsibility on the part of the employer in the case of sexual harassment from an employee to a customer. But for this bill, we don't have this. Can you consider enhancing the liability of employers? Because we talk about Hong Kong registered aircraft and ships. What should be the responsibility of the ship companies and airlines? And for Section 49, you're correct. In an education institution, there cannot be sexual harassment by a student to members of the education institution. So there are a lot of inconsistencies in the ordinance. Can the administration address all the inconsistencies in one go? And according to the Undersecretary, it is quite common nowadays for customers to sexually harass service providers, and therefore they have to introduce a bill. In the past, we thought that a victim may be in need of a job, of an accommodation, or to find jobs, so on and so forth. They had to put up with sexual harassment. And according to Tan Kapil, for employees who paid by commissions or tips, they're also under pressure to put up with sexual harassment. So when you conduct another round of public consultation, please address this. look at the spirit of the law and also the actual number of complaints. And please consider whether you should take into account unique characteristics of some trades and try to help these employees as well.
Yes, Undersecretary. Yes, Chairman, I agree with Mr. Chair. And I think we should also consult the SMEs, other employers, and we look forward to hearing more views at the hearing. And in the now we are proposing this amendment in the SDO. It doesn't mean that the rest of the ordinance doesn't require improvement. But of course, this amendment only relates to one part of the bill. Mr. Chair is also a member of the EOC. I understand that a consultation exercise is going on, and we will await the outcome of the exercise and see how we can further improve the ordinance. Ms. Helena Wong, I hope that the Bureau and the EOC can tell us more about the responsibility of the employer. Say, if a company's if a company owns an airline and the passenger sexually harasses the air hostess, then does the employer have vicarious liability? Say if the employer hasn't done or hasn't exercised due diligence, and as a result his employee was sexually harassed, then the employer has vicarious liability. On the 24th of November 2012, there was a case stating very clearly that it was a court case stating that although the employer was not the harasser, he had vicarious liability. And in fact, we have warned the Education Bureau that if in schools there aren't courses on combating sexual harassment, there aren't guidance notes for the staff concerning how to prevent sexual harassment, then the principals also have vicarious liability. And so you can't say that the employer doesn't have any liability. And that's why I think we need to invite the EOC to come. Not all members are familiar with the part in the ordinance on sexual harassment. And so we like to have the views of the EOC on the enforcement of the ordinance. All right, so I think time's up. Is it that we should invite deputations to come? All right, agree? Do you all agree? So the clerk will make the necessary arrangements. AOB. Date of next meeting. I want to know whether you will invite the EOC to come as a deputation, giving it 3 minutes, or whether we'll be meeting the EOC at a separate meeting. Now, the EOC has dealt with many sexual harassment cases, so I think there should be a special meeting between us and the EOC. And then we want the DOJ to tell us more about vicarious liability and to tell us more about previous court cases. So I think we should have a special meeting with the EOC. And then we will also have a hearing to meet the stakeholders. And it seems that this bill may not be able to cover the tour guides of outbound tours. So, let's invite the relevant parties to the hearing, and then I hope that we can meet the EOC separately. All right, then let's have a hearing next time, and then after the hearing we can meet the EOC and also the DOJ. Yes, EOC plus DOJ. All right. And should the Bureau come as well? Of course, of course. Sorry, because this is the first time that I am the chairman of a Bills Committee. So we'll have a hearing next time, and then after that we can meet the EOC and the Bureau and the DOJ. So when are we going to have our next meeting? Chairman, because we're going on an overseas study tour, so please schedule the meeting up to 14th, and then there will be a study tour to Singapore from the 21st to the 25th of September. I think after the 25th of September, end of September will be fine. Right, what about the 30th of September then? All of us will be back by then, but I have to check whether I will be in Hong Kong. All right? Either the 29th or the 30th, all right? 29th of September. There is a subcommittee on railways meeting in the morning. What about in the afternoon then? Chairman, because I have to teach on the 30th in the morning. Then there will be a public hearing on the third runway, economic development panel, the afternoon, and then also EA panel special meeting in the morning on the 30th. All right, so let's have a hearing at the end of September or in early October. I'll ask the clerk to ask members what the date should be. So no AOB items, meeting adjourned. Thank you for coming.